Well, okay, folks, here we are once again back at the Alberti Show. And today is a lovely day here in the town of Pahrump, Nevada. Actually, every day is a beautiful day in Pahrump, Nevada. I moved here because I really like sunshine. And I realized that there was hardly ever any rain and very few clouds in this town. So glad to be here. Now, today I would really like to get into some things that have to do with our responsibilities and how the legal system works from my perspective. And the issues of what's fraudulent and how do you deal with some of those issues. One of the questions that has come up recently in our discussions, typically at the men's breakfast on Thursday morning, has been the issue of who owns your stuff. You know, we go shopping, we earn money, we pay bills to buy things. We have a chainsaw, we have a car, we have a house, great TV set, clothing on our backs. We own all that stuff. But the real question became, to me, in the early 1980s, at a training session we were at, what do you really own? And this lawyer, Jay Schwab was his name, made the comment that you don't own anything. And now I was a real estate broker at that time, and I'm thinking to myself, what do you mean I don't own anything? I own this house. That's my car. His presumption was, if you owned it, when you die, you could take it with you. And you know you can't. That being the case, technically, everything you say you own, you are renting until you die. You have the rights, you have bought rights to use it, but you don't own it. Now, to me, that's an interesting concept. And as I've thought about this ever since that time. And in this year of 2021, I thought maybe we might examine a little bit of that question. Do you really own what you think you own? Now, there was an item in the Bible. Now, I'm not a Bible thumper, believe me, by any stretch of the imagination. I've come to like and enjoy reading it and kind of digging into the depths of what's in the Bible. And from what I can tell, you don't own anything. You get the right to use it. And here's what it says in Leviticus 25. Thank God I didn't say this, but I'm going to read it. No land shall be sold outright, because the land is mine, and you are coming into it as aliens and settlers. Throughout the whole land of your patrimony, you shall allow land which has been sold to be redeemed. Well, I guess that means that when you die, that land is redeemed back to whoever it is. And it goes on in another sentence to say, if the man cannot afford to buy back the property, it shall remain in the hands of the purchaser till the year of Jubilee. It shall then revert to the original owner, and he shall return to his patrimony. Now, these were the words that the Lord spoke to Moses, according to this part of the Bible in Leviticus. Leviticus 25, by the way. So I got to thinking about that. Who does the land revert back to? It was the Lord's land, or God's land, if you will. I can't think of anybody else that ever owned it. So who does it usually, you have to go back and look at this. But that's all I want to say about that part right now, because I think what's even more interesting is, what do we really own? As I said earlier, Everything you bought, you can't take with you when you go. So who owns this land? The Indians, the American Indians, the Native Americans, if you will, I don't think were the original owners of this land. I don't know who owned this land originally, because according to the scientists, you'd have to go back 4 billion years to the creation of this land, if that's the case. So who owns it? If the Native Americans took it from someone else or settled it after someone else lived here, which is quite possible after we start looking at all the archaeological digs that are taking place, it turns out that I don't think they own this land, even though they want to make claim to it. Obviously, the original settlers didn't own this land when they came here. They took possession from someone else. And when you die, who are you going to give it to? You're just going to wind up transferring it to one of your relatives who probably won't take good care of the land you gave them. So they'll sell it to somebody else ad infinitum. But let's talk about why you own this land and what's on it. How did you get the land? Well, the federal government allowed settlers to go out west and colonize the rest of what's now known as the United States of America. And then they said, okay, we have given you a certain amount of acreage to settle and colonize. Okay. When Columbus brought people here, or actually he didn't bring any more after he came, but when they settled after he came to America and communicated what he had found, when that happened, the land essentially wound up getting transferred by force to the new settlers. And they were not the nicest guys in the world. If they were, I don't think this would have ever happened. So now we have the United States government, one of the most powerful governments in the world, with its tremendous armies and bureaucrats who go out there and threaten the very lives of the citizens and their well-being who live in our country. Who owns the house you live in? Let's address that question first. You went out and you found a real estate broker or did it on your own with a fair sale by owner or however you did it. And you paid to buy that house. Now you own it. Well, technically that's not true. The bank loaned you money in which you agreed to pay the bank, and then you would own it. So in the meantime, the bank actually owns the property that you think you own, and you are paying the bank money that they loaned you so you could live there while you want to own it. And let's say we get to the point now where you paid off your house. Now this is where it really gets interesting. So now you own that house without the bank's intervention. Without the bank owning it, you don't have to have certain types of insurance. You could be uninsured. You could be self-insured. You don't have to pay the government for special insurance to cover floods and things because the bank doesn't care. They don't own it anymore. You do. You really own it now because the bank is no longer involved. But now what happens? Now you have to still pay property tax. So technically, who owns your house now? Actually, your local government owns your house now. It may not show it on the deed that you have, but don't pay them their due, their taxes that they put on your property, and see what happens. In theory and in reality, your house could now be sold for failure to pay the taxes. And when that happens, certain rights of redemption can occur, but they don't last very long. So that house you owned was not really your house. The government owned your house because you had to pay taxes to keep it, just like the bank. You probably have never looked at things that way, but you can't pay your taxes in advance. That would be ridiculous to do. You can't refuse to pay your taxes because you'll take your house and sell it to someone else who will pay the back taxes with hardly peanuts compared to the value of it. But do they really own the house? Hell no. They have the right to use it and not to create waste on it, if you will. Now that's true of almost everything that exists. And I'm bringing this part up because I wanted to talk a little bit today, not just about who owns the land and who owns your house. I mean, let's take a look at this before I get to that. Who owns the land throughout the state of Nevada? Maybe you moved here from California. Maybe you've lived here all your life. And you never really cared to ask the question, who owns the land? In reality, if you go and you check the records and you read the news, you'll find out that, like, let's take Nye County. Nye County is the third largest county in the country. The people who run Nye County, the county commissioners, control only 7% of the land in Nye County. The rest of that land is known as territorial land. And even the federal government claims they own that land, but they don't. They are caretakers of the land that the people own. Who are the people? You and me and everyone else who lives here. You used to have a say in how that land will be managed. I got news for you. Forget that. The Bureau of Land Management, the Bureau of Forestry, the Water Board in Nye County. There's a lot of intergovernment agencies that want to take control of some portion of the land to manage it. But if you talk to somebody from the Bureau of Land Management, the BLM, if you will, they will tell you they own the land. You can read articles in the news media talking about the land that the Bureau of Land Management owns. Now, there's nothing, I don't know of anything that says they can actually own land, even if it's given to them, because their mission is to manage the people's land. Now, the rest of the state of Nevada, 87% of the state of Nevada does not belong to Nevada government. It is managed by this bureaucracy known as the Bureau of Land Management. So you move to a state where the people running it only control 7% of what goes on here. And boy, they can sure screw things up, can't they? That's okay. It's not owned by the state. They have been given permission to manage the state, 7% of the land. Now, there are two documents that you can look up. One of them is called the Admissions Act. And the Admissions Act was taking place during the Civil War. And it is the negotiations that took place to allow Nevada to become a state. And then there's the Nevada State Constitution, came after that. Now, I can't say that it's fun to read it, but I can say if you don't read it, you don't have a clue about what the hell's going on around here throughout the state. And believe me, just because you think it's a certain way, it ain't. I'll tell you, when I first moved here, I thought I moved to a city. And I had been coming out here every couple of weeks to spend the weekend and just kind of cruise around, look at land and so forth. And I didn't realize this wasn't a city. It was a town. The town had some ability to govern itself, but it was really the county commissioners that had the ultimate responsibility. I would see people go to town board meetings and complain about the condition of the roads. Or when they built their houses, just dirt. And when it rained so bad, they got stuck in the mud and they couldn't get out. And they demanded that the town do something. You know, I sat in the audience and watched that at that time. And in reality, they were talking to the wrong people. They should have been talking to the county commissioners. But the way I see it, if you moved here when there was no road there, you should have checked to see when that road would be put in, because nobody knew. Matter of fact, we bought a piece of land because the road was already in on Unicorn Street, but we really wanted one a couple of blocks over, but that was a dirt road. So we bought the one we bought, and then found out 2 weeks later they were paving the lot that we were really interested in. So you had to do your homework. Okay, so I don't think you really own anything. Even the federal government, when they gave the land to the state, cannot come into the state to do things on Nevada land that the state manages and controls without permission from the state. Oh, they will get involved in interstate commerce, and that's a whole nother issue. But the last of that 87%, they will sell off pieces of land regardless of the desires of local governments for specific purposes. But maybe eventually we'll be at 86%. There were other things that have happened also, and I don't want to get into those now. One of them has to do with all of the townships that were created throughout Nevada and how they affected school districts. Perhaps on another show, somebody will remind me. Okay, so I've been involved in the past as a real estate broker in dealing with many, many people who have had financial difficulties. They have had lawsuits that they've had to deal with. They've had issues with the IRS over money. And the reason I'm telling you this as a preamble to what I want to talk about when it comes to the legal system is that I've been to court. I've been in district court in California in Orange County and in San Bernardino County. I've been to small claims court a number of times. I kind of have learned how things work. And I can tell you this, in my mind, I thought I knew how they worked. But in reality, I didn't. So my first foray into the small claims court was a tenant that lived in my condo, had a 1-year lease, and just wanted to get out of it. She just didn't want to stay there anymore. I was a good landlord. There were no problems. She just wanted to leave. And I told her no. I said, you can leave, but you'll have to reimburse me for the rent I would have gotten. Anyway, she went to small claims court and she prevailed. The court said that it didn't matter that she had a lease agreement and that she wasn't really moving for reasons of job or anything like that. And they decided in small claims court to negate my contract. I learned a valuable lesson then. Actually, I learned a few, but that was my beginning in getting involved in the legal system. And you know, most of the people don't even want to get involved in the legal system. But sometimes you just get dragged into it. You're doing a good job, everybody's happy, and all of a sudden, something happens. And now you're in it. And the reason I'm bringing this up, I want to talk about what exists in the legal system. You have the lawyers, and the lawyers go to law school to learn about the law in the United States. Now, at the men's breakfast, I brought up the fact that there were certain specialties in law. I'm not going to bore you with what they are, but there's like 23 different specialties of law that you could practice in this country. And let's say you're going to go and you need a lawyer. You know, they say a man who represents himself in court is just bringing damage to himself, potentially. And in most cases, I would say that's true. But if you've been there and you've analyzed what takes place in court, if you've watched court proceedings when you're there, other than just grumbling about having to be there, then you learn something. And here's what I got. There's the small claims court, there's district court, and in Nevada now there's the Court of Appeals, and then there's the Supreme Court. So you can work your way up the ladder. And there's this thing called you have to have standing to bring a lawsuit. In some cases, people think they have standing and they don't. But those are the 4 levels of court. And the courts were really getting backlogged. The colleges could not provide enough lawyers to handle the caseload. So some genius came up, I think it came up out of England, with a system called arbitration. And in the beginning, not everybody understood arbitration very well. I was fortunate to have been in my real estate business in an arbitration at the real estate division in California. And I also was in court over real estate. And here's what I learned. Well, let me go back. There were 3 kinds of ways to do an argument for a case. You can wait to go to court, in which case you get on the list of people to be heard. And if you watch small claims court, you can get in there fairly quickly. But when you come to district court or some of the other courts, my God, there might be 10, you watch some of this stuff on television, it might be 10 years before you get to trial. And whatever happened to due process? I guess if you're guilty, you want to stall off any court hearings. So, to me, having been in those 2 situations, small claims is easy. You can buy some books on small claims. No Little Press provides a book. But they don't tell you things in there that you should really know. Let me tell you a little story about small claims court. Because I think stories kind of stick with you rather than just the BS I'm handing out. I was in California and I owned a RE/MAX office. And in that office, I had real estate brokers, top of the line, high producing agents. And they only had like 10 agents. I mean, it wasn't a big office, but we were producing a lot of business. And one of my agents was Lou and Yolanda Sorensen. And they were brokers in my office. And one day they decided they were going to leave. I said, okay. And when they left, I stopped getting mail at the office for my business. On the second day when I didn't get mail, I went down to the post office. I asked them, is something wrong with my delivery? And they said, well, your mail's been forwarded. So what the Sorensens did, they forwarded the mail from my office to them when they left. Now, why the post office didn't ask for identification or to prove they had the original mail is beyond me. When I asked the post office to pursue this, they declined. So if you're going to do something with the post office, don't count on them doing a damn thing. They better be a really, really big deal. So anyway, they left with a commission as well. Commissions always come to the broker pays the agent or the broker associate. So they owed me about $3,000, and I went to small claims to collect. And we had a hearing in front of a judge, Happened pretty quick, like 30 days. And in the hearing, the judge decided that I was correct, that they owed me that money, or at least the company that money. But the Sorensens appealed. So on the appeal, they lost. So now I'm waiting for them to give me the money, and they're not giving it to me. And I read the rules, and the rules said, you know what? You can call them in for a financial audit, what I call a rectal exam on their finances. And let's find out how much money they got and why aren't they paying back the money they stole. Now that was stealing. They weren't going to jail over it. I suppose I could have reported it to the police. I didn't think about it at the time. So when we went to the court the next time, we were sitting in a room with a bunch of other people. And there was a guy at the front of the room asking how many people are willing to meet with a mediator. We urge you to do that, so maybe the mediator can help you settle the issue. Okay, I said, I'll do whatever. So did Lou say the same thing. And we went in there, and that didn't go anywhere. And now we're back out in the room. And by this time, Lou knows he's going to arbitration, and he's going to lose. No question about it. And I'm sitting there waiting for him, and he gets up and starts to leave the room. Well, when I see him leaving the room, I'm thinking, oh boy, he's leaving. I better follow him out. But he went to the cashier in the court, took out his checkbook and his wallet, and paid the cashier the money he owed me. Now, I was standing in line right behind him. I don't think he knew that, because he never looked back. And after he gave her the money, he left. I walked up to the window and said, the money you just got, I'm the person receiving it. And so they paid me right there on the spot. I had to prove some identification and all, but that was all right. So I hear people going to small claims court and not understanding how it works, not understanding what they have to do to win. You go there often enough and you watch the mistakes other people make, you start to learn. And you tell yourself, boy, I'll never do that. I'll tell you another mistake I made. I had an issue with somebody that had an office this is when I had a business, had nothing to do with real estate. They owed me some money, so they were in Ventura, and I was in Orange County. And I filed in Orange County, and it was denied. They said I had to go to Ventura, because that's where the guy lived. So, okay, I filed in Ventura. And the day of the court hearing, I drove up there, and that was a couple hours. And to make a long story short, after I lost that one, I asked the judge in the courtroom, this is small claims. I said, how can you decide to let him keep the money he owes me? And he said to me, Mr. Alberti, we live in this county, and we have to take care of our local businessmen. Now, I never realized until that moment that judge didn't care what the case was about. He was protecting somebody he knew, and I was out. All right, now I go to Nolo Press and I buy small claims, how it works. They don't tell you how it works. They tell you how they want you to know it works, but that ain't the game. And I have never written a book about how I deal with small claims actions. But I can tell you this. What you think of the rules, you got to learn to play the game. Football, you may know the rules, but when you get on the field, you better know how to play the game. And that takes practice and knowledge and learning and experience. I won't tell you any more than that at this point, because I want to get to the other methods of dealing with legal issues. Small claims court starts the process. And district court is a higher level court. Actually, judges in district court can create a grand jury. And here in Pahrump right now, in Nye County, one district judge has created 2 grand juries. I haven't heard any more about it lately, but I'm sure it's still in the works. They just haven't said anything. But I will be doing some follow-up on that in a future show. Now, let's say you don't go to court. There were 3 other things that exist to help you get your case heard. One is called a special master. How do you like that term? Does that sound racist or what? Special master. Whoa. Then there are things called mediators and arbitrators. Now, if you go to trial in local court, whatever court you go to, there's a person who takes the record, becomes the official record of the court. And you can research that. You can go back and look at those cases. You can find them online these days. And you can see lawyers go in and they look to see how does a judge rule in some kinds of cases. And if you're a smart lawyer, you start to know which judge does what. And sometimes lawyers will go judge shopping because they know how a judge normally rules in certain types of events. And I have an issue with that, but I'm bringing up this part because that isn't always the case. You can't always find out that kind of information. So let's go back to this special master business. You know, in real estate, they told us you can't use the word master bedroom. This was California. This is a few years ago. Can't use the term master bedroom. What are you supposed to call it? Bedroom number 1. What if bedroom number 1's a tiny bedroom? Usually master bedroom meant the big bedroom, you know, mom and dad, the king and queen that own the house that they don't really own but think they own. So what does a special master do? A special master is a judge that retired. And some of them, even though they retired, are willing to do some work to help people out and get their case heard so they don't have to wait unimaginable periods of time to get into court. That's a special master. So you look at this postings, you can find out who the special masters are, and you can contact them and find out if they're willing to hear your case. In which case, they have the effect of a typical judge because they've been a judge. And they're listed as the special master. And it's a regular trial. But you can get into court a lot quicker if you've got a long wait period by getting a special master. Well, you'll have to pay them, and they don't come cheap. But the difference between waiting 5 or 10 years to get to court, it may be well worth it. So after that, you have mediators and arbitrators. And a mediator is somebody, like when I was in there with the Sorensens in small claims court, they wanted us to go to a mediator. And the way that worked is this. The 2 of you sit on a table across from each other, close enough to hear each other, but not close enough to take a swing. And the mediator sits at the open end of the table to help you negotiate some sort of resolution to your problem. And in some cases, this is a good idea because nobody wants to go through the stress and financial cost of trial. Sometimes it's better off just to settle. I'm going to talk about that in a little bit, but in the meantime, so that if the mediator can help you solve your problem, it's well worth the time to do that. Now, and you will not know what negotiations took place because that's private between the 2 parties. You're not in court. So there's no public record kept that you can see. So you don't know how a mediator judges things, how he helps. And now there's the arbitrator. And the arbitrator's job is to listen to both sides and make a judgment call. So, and the reason I'm bringing all this up, I get a magazine. I get lots of magazines. This one's called HPAC, Heating, Piping, and Air Conditioning Engineering. And you know, you wouldn't expect to find something in there about this topic, but there it was. And it was an article that was written by an engineer, and the heading of the article was Forensic Engineering, Expert Tips from the Trenches. Well, I was in the trenches, and I have expert tips as well. We'll get to that later. So this man's name was James P. Waltz, and he had engineering credentials. And he would appear as expert witness in trials on this topic. So when he wrote this thing, I saw that, and I wasn't going to read it. I just kind of usually browse through the magazines to look at something that's interesting. But he wrote this thing, and I'm going to tell you some of the things he says. He says virtually all tort cases settle out of court. His statistics said that 90% of the cases never go to trial. They are negotiated out of the court. And I know from experience, from talking to other people and lawyers, that negotiation normally doesn't get settled until they're standing outside the courtroom door, facing each other, when some of that negotiation really starts and gets resolved. And a good part of that is because the courts are busy, and the cost of going to trial is really very consequential. So as a result, a number of the non-judicial means of settling legal disputes are employed, like arbitration and mediation. So here's his experience with these special masters, mediators, and arbitrators. He says a couple of things seem to be true about special masters. Their job is to see if the parties to a dispute can find a resolution without going to trial. Going to trial is very, very expensive. So usually if a special master has helped you come to a conclusion in a trial, nobody's going to be happy, but there is a result. And I really wanted to get to this part. He says another frequent phenomenon in these cases is what I call the nose count. In my experience, it seems it is only the people with insurance that end up paying the bill when a lawsuit is initiated. And I want to tell you that I found that out in the late 80s, early 90s, when I would read articles about lawsuits that were gone against a whole bunch of people, businesses and everything. The people who wound up paying were the ones that had the best and most insurance. So he goes on to say, when a settlement conference is held by a special master, all the defendants and their counsel are brought together in a big conference room. The special master will say something like, well, we have $1 million claim. There are 10 defendants in this room. That means you are each in for $100,000. Whatever happens. Then the special master will ask, who doesn't have insurance coverage? Perhaps 5 defendants will raise their hands. And the special master will tell them something like, well, you can go. We're not interested in you. After the room clears, the special master will clear his throat and say, okay, now the rest of you are in it not for $100,000, but for $200,000 each. And the conference will continue. Now, this man swears to the fact that he's been in those cases because he wasn't being sued. He was expert witness. And it seems in civil suits that the ability to pay is the only thing that determines whether you're culpable. I'm going to say that's not necessarily true. But in civil suits, those who have the deep pocket wind up paying the bill. Happens all too often. I mean, why go to court and pay a lawyer $50,000 for your case and find out you're going to get 10 grand? Even the lawyer doesn't want to do that case. So he goes on to talk about the fact that the obvious conclusion is that carrying insurance in many circumstances is like hanging a sign around your neck that says, please sue me first. And that the only sensible course is to not carry insurance, which runs contrary to the conventional wisdom. You'll recall that uninsured motorists, if you carried insurance, you got covered. So now everybody has to have insurance in order to get license plates so they can drive. There's a little bit of this in that scenario. So I found that out when I went to that class with Jay Schwab. The trick is don't be foolish enough to show all your cards in the beginning. And one of those cards is your insurance carrier. Then he goes on to talk about his experience with mediators. And mediators are along similar lines as to what the judge does, but most mediation takes care in smaller cases. And I went to a mediator over a large check, and I had a lawyer. This is my first experience. I got to tell you this. A fellow bought a house from us. We represented the buyer in Long Beach. Now, he never told us he used to live in that neighborhood. We knew he lived in Long Beach, but not that neighborhood. And he was a real estate appraiser. And he was a licensed realtor. And he actually did live in that neighborhood. And it turns out that when we closed escrow, the very next day, somehow like magic, he learned that that house had been sinking and they pumped it back up and it looks okay. Now he had a home inspector go through the house and he had the paperwork from the owner not disclosing this, and there was nothing in the public record to show that this occurred. The day after we closed escrow, he calls us up to tell us that he just learned that that's what happened. And he wanted $35,000 to compensation, or he was going to court. So he went to court and filed a claim. And I had never dealt with this. And this guy, he never told us. We knew what his credentials were. We had confidence in him. You're not supposed to do things that are illegal. Anyway, long story short, there's a trial date set. And he's suing, and we had E&O insurance. And the E&O insurance required a $5,000 deductible for the insurance company to work on the case. And the insurance company told us, the minute you get a letter in the mail telling them that they're going to sue you, you need to send a copy to us. Well, now I'd been down this road with insurance carriers before. So before I signed on with this company, I asked them, if a lawsuit comes down the pike, who's responsible? Who gets to decide what we're going to do? Do you get to decide you want to settle, or do I get to decide I want to go to trial? And they told me, oh no, Mr. Alberti, you're in full control over what happens. Good. So now that this complaint has come in, they let me know they want to settle for $35,000. And I told them, no, I don't want to do that. And I'm not paying you the $5,000 you think you're going to get to settle. Because he committed fraud by not disclosing his position here and what he already knew. And then we negotiated back and forth with the insurance company. And finally, one day I got this bright idea, and I called them back and I said, look, I want to take this guy to court. I want to take him through the ringer. I'm not paying you the $5,000. What I want is for you to pay me the $35,000 you want to give him I'll give you a release of liability so you don't have to worry that I'll sue you over anything. And then I'll take that $35,000 and I'll take him to court. I'll countersue. You know, they didn't want to do that. But they agreed that I didn't have to pay the $5,000, and then they gave him the $35,000. It doesn't say anything about that in the rule book. It doesn't say anything about that in their contract with us. But if you look at the scenario and you think that you're right and they're wrong, give them a waiver. Tell them give you the money and you'll go do the job. Because here's the problem. For what that man did, there should be a court case to show the results, because everybody looks at court cases that come together like that. And if you do an arbitration, that's not going to happen. So there's just one instance of knowing how to deal with an issue that's troubling. That actually happened twice. So you should know that not everything is as it's written. Sometimes you could win. Now you could go to arbitration. And here's what happens in arbitration. The arbitrator is generally given the power to decide an issue between the two parties. And you have to know how to pick an arbitrator. I just learned something the other day that I didn't know before. Anyway, you have to learn how to pick an arbitrator. So if you go on the internet and you go on a website for the American Arbitration Association.com, you can get a copy of their rules, because most arbitrations are conducted that way. And what it tells you in there is that each side can pick 3 potential arbitrators and see if they can both agree on one of those 3. Well, we couldn't. And in that case, the American Arbitration Association will pick the arbitrator. Now, in the public record, there's nothing you can find in the public record as to how they make their judgment. You go in and it's testimony, just like as if you went to court. And it actually is court, but not in that sense. And there's no record kept. It's private. So you have no way to tell how these people decide issues. Now what do? How do you pick one? Well, sometimes you make a mistake. I made one there, and it was a big lesson for me. But I learned just the other day something that I thought was interesting. When they say you can have an arbitrator, it is possible for you to have 3 people as the arbitrator. I don't know how all that works, because I have no intention of ever going back to arbitration. It's a crapshoot. So when you get a credit card and the credit card says that you agree to arbitrate even before you know there's an issue, I would never do that. One of my credit cards sent me a letter once. And, most people don't read that crap that comes in from with the fine print. But I read it. But I don't read every word. I go in and look for the things I think are important. And I found a sentence in there that said if I did not want to arbitrate, I could call them and then send a letter indicating I want to be removed from the agreement to arbitrate. And so with that credit card, I'm out. Now, maybe I do want to arbitrate something. I just don't want somebody to decide that I always have to do that, because I don't trust arbitrators. So here's what this guy says about this guy. What he wrote is everything I've talked about for a long time. Finally, arbitrators are yet another horse of a different color. While non-judicial arbitration is typically binding, which means you're stuck. By the way, I found out that you don't have to be stuck. There's a way around it. And most often includes recovery of all legal costs by the prevailing party. Now that's a big deal. Whoever wins does not have to pay anything. The loser pays. So arbitration, in this guy's opinion, is definitely a form of rolling the dice. Now, it could be conducted by one arbitrator, or you could have a panel of, say, 3 arbitrators. And it doesn't have to be a lawyer. Most people don't think that. They go find a lawyer. No, no, no. An arbitrator could be an expert in that field. How do you determine who's an expert? That's another discussion. Probably longer, longer than we want to get into. So, unlike most of the processes conducted by special masters or mediators, everything in arbitration is done under oath. So a guy like this forensic engineer who's writing this, as expert witnesses, they really must have their act together and choose their words wisely. He closes this article by saying, curiously, I have found it not unusual at all for even highly regarded forensic engineers to state views that are not at all expert opinions, but really just their personal opinions that are often quite unfounded. While the proceedings are quite formal, there is a widely held belief that arbitrators, much like Solomon, generally choose to split the paper. That is not my experience. I was actually in an arbitration over the purchase of this Remax office when we bought it. And in there was a clause that said the guy that owned the real estate, the Remax office before me, could not compete in my territory, which was San Bernardino County and parts of Los Angeles County. Don't you know he goes and opens up another office, competitive? Well, I refused to pay him any more money because he violated the contract. He wanted arbitration. So he knew people in the town of Chino, and the arbitrator was the attorney for the city of Chino. That's who they picked to be the arbitrator. All these guys were buddies. Now, when we went to arbitration in that scenario, the other guy and I, the 2 people that have the butting heads, if you will, are sitting in the lobby waiting to be called in for the arbitration. Instead, after an hour, the 2 attorneys come out and they tell us what they've decided. What? I said, that's not going to happen. I want to be in the arbitration. It's about my issues. And they said, no, we already decided. We had the arbitration held without you. What do you mean held without me? I'm sitting in the lobby here. So I told them no. So they agreed that they would have another day to have the arbitration. So now we're in another day. We're sitting in the arbitration with the arbitrator and our lawyers. And I start to make comment about what we saw, what the issue is. And the arbitrator says to me, Mr. Alberti, you don't speak here. I said, what do you mean I don't speak? It's my arbitration. He said, well, you have a lawyer. The lawyer will speak for you. Well, that really ticked me off. So I turned to my lawyer and in a very loud and clear voice instructed him as exactly what I wanted him to say. The arbitrator could hear it. The other side could hear it. And the arbitrator said to me, all right, Mr. Alberti, I get it. You want to speak. And at that point, I knew I had a bad arbitrator. And I told him, you know what? I'm not sitting in for this arbitration. I'm out of here. And you know what? That was the end of the arbitration. Period. To me, I don't like everybody being friendly in an arbitration. If there's 2 lawyers, I don't want them calling each other Bill and Bob and calling my lawyer Mr. Goose. No. If they're going to be Bill and Bob, my lawyer is going to be Ed. I have one of my lawyers. I told him I would give him the right to represent me in a case, but I wanted to be involved in every conversation and communication he had with the other side. And he agreed. So if he got a phone call from the other side, he would put them on hold and patch me in on the conference call. And I could listen. I couldn't talk, but I could listen. And here's what I heard. I don't think they were thinking, because I heard most of their conversation about scheduling, whining and complaining about when they had vacation time and holiday time and family time. There was nothing in there about the concerns about the clients. They were being paid for that time. I'm sure they billed it. And if you don't ask for that with your lawyer, you should get another lawyer. If he doesn't want to do that, and I had a couple of other lawyers said they wouldn't do it. I walked out. I was a businessman. I wanted to know what he's doing. Just because he's an officer of the court, licensed by the state to practice law, I wanted to be involved in everything that took place. And when I talked to my lawyer about that problem, he said, oh, I don't think that's anything. But you know what? When we went to arbitration, it was everything. I won't tell you how I resolved that issue, but I did. And I felt very good about the resolution. So that's pretty much what you can see in the court system. Now, maybe you don't care about what I'm telling you today. Maybe you just listen to stories. But I will tell you this. Who are you going to ask that's not a lawyer about how things work? I sat in on a bankruptcy once. And at the end of the bankruptcy, there were taxes that were not covered in the bankruptcy. And I asked the lawyer, I said, wait a minute, how come you didn't tell me that I could put taxes in this bankruptcy? And his answer was, well, you never asked. Now, therein lies a clue that you should all listen to. Yes, you should ask everything and anything, even if it sounds stupid. The only thing stupid will be the answer you get. Every question you ask is important. No matter how silly you may think it is, it might lead to another question and another question, in which case you'll become a lot smarter than you were when you walked in their office. I went to a lawyer here in Toronto about an issue on trust. As far as I was concerned, when we got done, I actually knew more about the trust business than he did. Now, he had things I don't have. He had a law degree. I don't have one, but I had common sense. And one of the things I learned from Jay Schwab, going back to the beginning of the show, about that lawyer who taught this 5-day seminar, was this. There's a guy named Steve Weiner in Florida. I don't know if he's still alive. But if you have a family trust, the lawyer says, well, how do you want to name your trust? Do you want to put the family name on the trust so you know? And you'll usually say yes. This morning I asked that question of everybody at breakfast. I saw a bunch of hands go up. They put the trust in their family name. There is nothing in the law that says you have to do that. You should name the trust not your family trust. You should name that trust something like the Washington Deficit Trust. I like that name. And you could be Washington Deficit Trust with a date. Because what's going to happen is they're going to look to see if you have a trust. I don't think they're ever going to find that puppy. Well, in closing, I want to say one thing. My close and dear friend, Joe Markley, passed recently at the age of 83. He used to come to breakfast. Joe was a great guy, a good man, honest, lots of integrity, and a good friend. With that, this is Andy Alberti. I am your #1 host, in my opinion, and now I am out of here.